to start?
I think so, Your Honor.
All right,
Your Honor, I guess, especially given that you indicated you would like to limit argument to 20 minutes per side, I would appreciate if you could provide us with any sort of hints about what you're thinking and in particular issues that you would like us to emphasize. Obviously, we can't cover everything in 20 minutes.
I'm not going to limit you to the 20 minutes. So what I'll do is I'll let you essentially proceed as you see fit.
Very good. So let me start talking, start at the beginning with standard of review. And we've had some discussion in the briefs about whether this is under Code of Civil Procedure 1085 or whether it's under 1094.5. But frankly, I don't think that makes a difference in terms of the standard of review. The basic issue here is that Prop 1A was approved by the voters and set some certain requirements on the High-Speed Rail Authority and on other government officials about their duties under that ballot measure. And those are mandatory duties, and our position basically is that when you have a writ that is issued to get a government agency or a government official to perform mandatory duties, then the standard of review is basically substantial compliance. That they need to comply, and let me quote the language, actual compliance in respect to the substance essential to every reasonable objective of the statute. And that's as distinguished from mere technical imperfections of form. And the issue particularly has to do with the funding plan that the authority, again, under Prop 1A, was required to submit. And that funding plan had within it certain requirements set by the statute that was approved by the voters. And among those were a series of certifications. And those certifications, each of them was quite specific about what it required. And there are two of them specifically in terms of this writ, these writ causes of action that we're that we're arguing today, that we assert that the authority didn't comply. One of those had to do with basically the assertion that, that's the exact language, construction of the corridor or usable segment thereof can be completed as proposed in the plan. Excuse me, the plan meaning the funding plan. And the second one was the authority has completed all necessary project level environmental clearances necessary to proceed to construction. And we submit that essentially the authority did not properly comply with those mandatory requirements. And there's a lot of things that roll out of that. But basically the issue is you have these requirements, the standard of review is they have to comply, and they have to comply with every reasonable objective that was contained within those particular requirements. The authority has argued in its opposition that that the court should interpret those requirements as being basically just for the benefit of the legislature, and that's the only reason those are there, and it's up to the legislature, not the court, to determine whether the authority complied properly with those requirements. Well, that's nowhere in the ballot measure. There's nothing in the ballot measure that says these are for the benefit of the legislature. And, Your Honor, I think the plain language, as you know, in interpreting a statute, the language of the statute is clear. You don't interpret it. You take it as it is written and as the voters approved it. And that's particularly true when you're dealing with something that's going before the voters, because voters aren't going to know very technical type terms or legal interpretations of what a particular term means. Voters expect when they read something in the ballot, it means what it says. And interpreting what the voters approved, you have to look at what was the intent of the voters. And in looking at a ballot measure, the intent of the voters is, in general, going to be what the language says on its face. And so that's really, you don't go behind the language unless there's an ambiguity, something that's not clear on the face of language. But if you do go beyond the face of the language, I think the issue here is do you give the authority a lot of deference in its interpretation? And I think the answer is no. And there are a couple of reasons for that, and those are, for the most part, explained in the brief. A lot of that has to do with the Yamaha case, which basically explains how much deference you give, and it says, well, the amount of deference you give depends on the specifics of what exactly is where did that interpretation arise from. And at the one end, it says is where you have a formal process with input and lots of opportunity for everyone to have their say, and you come up with really a written regulation and says this is how this statute is going to be interpreted. That obviously didn't happen here. The other end is when you have an informal analysis and an informal interpretation made long after the fact and made in relation to a specific singular event, and that's exactly what this is. This is an interpretation that the authority has come up with for this case. It's not even something they came up with prior to issuing the bond measure, prior to issuing the funding plan. It's basically after this case was filed, they've come up with this idea that, oh, this is just for the legislature's purposes, and nobody else has any standing to challenge it, and given that it's the legislature's decision, the court should essentially bug out. And there's very little reason for the court to give any deference to that interpretation, because, again, none of the standards that would basically say you have a reason to defer to this are present. There is a reason, however, to not accept that interpretation, and this goes back to the nature of what we're dealing with here, which is a bond measure that was put on the ballot and asked for voter approval. And there are a lot of cases on bond measures that say that a bond measure is essentially a contract. It's a contract between the government, between the agency that put the measure on the ballot and the voters. And when the agency puts it on the ballot, it's essentially writing a contract. And when the voters approve that measure, they're essentially signing their name and approving that contract. And it's one of the basic principles of contract law that if a contract is written by one party and there's an ambiguity in the contract, you interpret that ambiguity against the party that wrote it, because it was their responsibility to write it clearly. And it really actually also goes back to the O'Farrell case and the question about, well, how much discretion does the authority have here? And what the O'Farrell case said very clearly was, well, when you put a measure on the ballot, the agency that's putting the measure on the ballot has a lot of discretion. They can decide exactly what they write and what they put on the ballot. But once they put it on the ballot and the voters approve it, they've exhausted that discretion. They had a choice when they put it on the ballot to decide what they put on the ballot. And when they made that choice, they're committed to it. They can't argue later on, well, that's not what we meant. Because the question is, it's not what they meant. The question is, what did the voters believe? The question is, what does the language say, and what would a reasonable voter believe based on that language? So that's essentially going sort of a little bit into standard of review, and also into sort of how do you interpret these requirements that are in the measure, and how much deference to give the authority. So having gone through that, let's talk about actually what did the authority do and did they comply. So the authority in November of 2011 approved the funding plan. And that funding plan required that the authority make 5 certifications. And let's talk a little bit of what that means. The authority argues that all these amounted to was providing information to the legislature. And the legislature could do with it as it saw fit. It would look at these certifications and say, okay, so the authority says they can do this. The authority says this is how they're going to handle the environmental clearances. Looks good to us. Let's go ahead. But a certification is more than that. The dictionary definition of a certification, let me find it here. To certify, this is from the dictionary, from Webster's dictionary. To certify means to declare something true, accurate, certain, etc. So essentially, what the authority is being asked to do by the ballot measure is to state with certainty that the following facts are true. And given that it's a governmental agency, there's an understanding that if a government agency says this is true, it's the same as if it was done on the penalty of perjury. That's why, for example, when you have a verified complaint, a government agency isn't required to verify its complaint under penalty of perjury, or when it's answering a verified complaint, it isn't required to answer under penalty of perjury. It's assumed that what it's saying is the truth. And that's a big burden. You don't just say something casually when you're having to vouch for its truthfulness. So we think it's more than just providing information. It's providing information that the authority was certifying is accurate and truthful. And that carries an extra burden on it, and we think the authority dropped that burden. And it's not for the legislature to decide whether that information was accurate. It's for the court to decide whether that information is accurate. Because the legislature was really in a position to just sort of say, well, okay, they gave us this information, now let's just go ahead and act. But when it put into the ballot measure, it's making it binding. And it's for the courts to see, did in fact the authority carry its burden in providing the true and accurate information to the legislature and to the public, or did it not? So, and the other thing that defendants say in this case in terms of they say there's no remedy. Because the legislature went ahead and approved the appropriation, and the court cannot take action to order the legislature to undo what they've done. And the court cannot enjoin the legislature taking action because of separation of powers. Well, that's all well and good. Obviously, the legislature does what the legislature does. But that doesn't mean that the courts are powerless. And there are lots of cases, and I cited one of them extensively in my brief, the Shaw versus People ex rel. Chang. And another case to the same effect is Consulting Engineers and Land Surveyors of California Incorporated versus Professional Engineers of California Government. And that's a 2007 case, 42 Cal 4th 574. And both of those cases say that the court can use declaratory relief to address something the legislature did improperly. And so in other words, the legislature approved an appropriation. This court can't go back and tell the legislature to unapprove that appropriation, just as this court could not enjoin the legislature from taking action. But what this court does have the ability and the authority and indeed the duty to do is if it finds that the legislature's action was improper, it can declare that that action is invalid because it was improper, because it was essentially ultra vires, beyond the legislature's power to do what it did. And if the legislature does something beyond its powers, just like any other entity, the court has the power to declare that action invalid under declaratory relief. And we think that in terms of the legislature's action, we think that's the appropriate remedy here, is declaratory relief. In terms of the authority, we think that a writ action is entirely appropriate. The authority, as we say, had a mandatory duty to approve a funding plan that met the requirements of Proposition 1A. If it didn't carry out that mandatory duty properly, if the funding plan did not properly meet the requirements of Proposition 1A, then it's entirely proper for this court to order, by a writ of mandate, the authority to undo that, to rescind that approval, and basically say, if you're going to approve a funding plan, you need to do it right. You need to do it as the voters said you needed to do it. And actions that the authority took following up on that are likewise subject to a writ of mandate. So in particular, one of the things that the authority did in following up on approving the funding plan was submit a request for an appropriation to the legislature. And we submit that that request for an appropriation, because it was based on an invalid funding plan, was also invalid. And essentially, in terms of the legislative action, if the request for the appropriation was invalid, then the appropriation itself has to be invalid, because an appropriation request has to start with an agency. The legislature can't just on its own go ahead and say, oh, we're going to give the High-Speed Rail Authority $500 million or $10 billion, however many. It doesn't work that way. The way appropriation process works is it starts with the agency requesting it. And the agency did not properly request it because its request was based on an invalid funding plan. So without a proper request for an appropriation, it was ultra vires for the legislature to go ahead and grant an appropriation. And consequently, that appropriation has to be declared invalid. So let's finally get down to what exactly are the problems with these certifications that the authority made. So we're challenging two certifications. One is the certification that the construction of the corridor or usable segment thereof can be completed as proposed in the plan. So the funding plan identified one of two initial operating segments as being the usable segments, either what's called iOS North or iOS South. The business plan, the revised 2012 business plan that was submitted later, clarified and says, actually, we are focusing on iOS South. And given that the business plan was included in, by incorporation, the funding plan, then the revised 2012 business plan was presumably incorporated by reference into that funding plan. And so essentially what the funding plan says is we're doing iOS South. So what this certification had to say was we can construct iOS South. We are going to be able to successfully complete iOS South. And there's two parts to that. One is the technical part. Does the authority know that it's technically feasible to build this operating segment? That there are no insurmountable technical difficulties? And we're not contesting that part of it. But saying you can successfully complete it requires more than that be technically feasible. It also requires that it be financially feasible. Now, we're not saying that the authority had to actually have all of the funds in hand to complete the segment. We understand that would be perhaps unreasonable at this stage of things. Perhaps at the point where they start construction, it would be more of an appropriate question, and indeed the revised funding plan is required to make that certification. That yes, we have all the funds in hand to complete the operating segment. But at this point, it doesn't say that. What it says we can successfully complete it. Well, that means you have to have a reasonable understanding that you have the funds, that you will be able to get the funds. And I guess the emphasis would be on a reasonable understanding. It can't be mere hand-waving. You have to be able to say, we know we're eligible for this money, we know we're eligible for that money. When you took all of this money together, and we think it's reasonably possible for us to get this money, and based on that, we think we can go ahead and say, yes, we can complete this.
Isn't that a question, though, that leads to degrees of certainty? And how does the court reach a determination with regard to that degree of certainty?
I think the answer there is basically there has to be substantial evidence to support the agency's determination. There has to be evidence in the record that says, yes, it was reasonable for the authority to make this determination. Just as with most issues involving substantial evidence, the agency is being asked to decide something. And the question is, did they have evidence to support that decision? And here the decision is a conclusion, yes, we can do this.
But isn't the issue even more complicated by the fact that it's, in effect, a reasonable expectation as opposed to some reasonable certainty?
It's a combination of those two. The fact that it's a certification means there has to be a certainty to it. But again, it's a certainty that the expectation is real.
Explain that to me.
Okay, let's say I'm saying I'm going to go to the store this afternoon. Well, if I've already planned it all out, I know the store is open, I know I've got the money, I've got figured out what I want to buy, then for me to say, I'm going to go to the store this afternoon, I think that's something I could certify with a reasonable degree of certainty. But on the other hand, if I say, I'm going to go to China 2 months from now, and I haven't even looked at, are there even planes going to China? Do I have the money to go to China? Is any of this really going to happen? I don't know. I would say I can't make that certification. I'm going to go to China in 2 months. Because there's not any evidence to make it clear that, yes, I have a reasonable expectation of being able to do that. And the reasonable expectation has to be based in substantial evidence. So, in other words, if, let's say, for example, the authority was seeking federal funding, and they had a letter from the federal agency saying, we have this program that you would be eligible for that would give you $15 billion. And, we can't guarantee that you'll get it, but you should go ahead and apply for it because you're eligible for it and we can give it to you if it's appropriate. I would say that would be a reasonable expectation that, yes, we can get that money. We don't know that we can get the money, but the program's there. We're eligible to apply for it. If we have the letter from the federal agency saying we're eligible to apply for it, we think we have a reasonable expectation of getting it. But they didn't have that. They did for $3 billion. They had the ARA funds, and indeed those funds they had assigned, I'm not sure if at that point it was assigned grant approval, but they certainly had a reasonable expectation based on the representations made to them by federal authorities. We're going to get $3 billion from the federal government. But when you read through the funding plan and you read through the expenditure plan, neither of those goes beyond that in terms of, well, what other programs are out there that you know that are there, there's money, real money, and you can apply for it and get it. There are hand wavings. There are possible programs that maybe will exist, and we should be able to apply for them if they come into existence. But none of it is based on anything that's passed through Congress, has been signed by the President. There's no reasonable expectation that that funding will ever occur. And indeed, again, given the Congress that the authority was looking at in 2011, it was pretty clear that there was not a reasonable expectation of any more federal funding. Everything that the authority could hear and was in the record indicated just to the contrary. There's nothing in the record that says, here's this program that we've set up and you're going to be eligible to apply for it. There was hand waving. That's all there is in the funding plan. That's all there is in the expenditure plan. And that's all there is in the record. And when you look elsewhere and say, well, what other funding could they apply for? The funding plan itself admits, we're not going to get any local funding until the iOS is set up and running. And we're not going to get any private funding until the iOS is set up and running. And in fact, in terms of state funding, they basically said, well, we've got this $9 billion, and that's it. That's all that's identified in the funding plan, is saying this is what we can count on. Now, the revised expenditure plan that was issued in April, at that point, they finally realized, we really need something beyond what we've said, because there's no way we're going to get $27 billion out of $3 billion plus $3 billion, which is essentially what they knew they could get between the bond measure and the federal ARA funds. So where are we going to get the rest? And they pointed to the proceeds that are going to come out of the auctions for the cap and trade. And they said, we think we can get money out of that. But if you look in the record, the question is, was that a reasonable expectation? Even assuming, admittedly, that was done in April, they certified in November. So even that's really a stretch, because how can they certify a program that they weren't even pointing to when they made the certification? There's nothing in the funding plan or the draft expenditure plan, which is what the authority had before it when it made its certifications. There's nothing in there that even talks about cap and trade. Nothing that mentions any other state funding other than the bond measure. But even if you were to accept that, if you look elsewhere in the record, what you see is the comments of the agencies that were basically reviewing that expenditure plan, and particularly the Legislative Analyst Office, said, you know, that's crazy. There is no way that this program is going to get cap and trade funds, because cap and trade funds are supposed to be for the purpose of reducing CO2 production. And in the near term, this program is going to increase CO2 production. So how can cap and trade, which has a mandate on it, a legislative mandate saying this is what this program is supposed to do, it's supposed to reduce CO2 production, how can it provide funds to something that's actually going to be increasing CO2 production? And the Legislative Analyst Office said this is wildness. This is a crazy dream. This is not certainly anything like a reasonable expectation of funding. And to call this a backup is to say there's no backup. So essentially, the problem is that even saying we don't have to have certainty, all we need is a reasonable expectation. There's no substantial evidence to support that reasonable expectation. It's not like my going to the store this afternoon and knowing I've already got that the store's open, I've got evidence that the store's open, knowing that I've got the money in my pocket, I've got evidence I can do the shopping, and knowing that my car is parked out in front. You know, all of these things that one would say give one a reasonable expectation of being able to complete what you say you're going to complete. They didn't have any of that. So that's the first of the two certifications. The second one is actually, if anything, even more clear, because the second certification that was required under the expenditure plan was, quote, the authority has completed all necessary project-level environmental clearances necessary to proceed to construction. That's what the authority was required to certify. Well, they didn't. They did a different certification because they knew they couldn't make that certification because they didn't at that point have any environmental clearances. Not only didn't they have the environmental clearance for the Fresno to Bakersfield segment of the initial operating segment or even the initial construction segment, they didn't even in November of 2011 have an EIR completed for the Fresno to Merced segment. And we're not conceding that that's the only clearances they needed. We think they needed other clearance. They needed clearance from the Corps of Engineers. They needed clearance from Fish and Wildlife Service. They needed clearance from the State Water Board and the State Air Board. There are a host of different clearances, and there's a declaration that you've received that basically lays out all of the environmental clearances that this project needed for the IOS and even for the ICS. And in November of 2011, they didn't have any of them. So it's very clear they were not in a position to make the certification that the ballot measure required. So they kind of said, well, okay, we can't do that. We'll do something else instead. And maybe that's enough. So they certified in connection with the initial construction segment, not the initial operating segment, just the initial construction segment. So only 130 miles rather than the whole distance from Merced to the San Fernando Valley, which is the operating segment. So just for the initial construction segment, the authority will have, prior to expending bond act proceeds requested in connection with this funding plan, completed all necessary project-level environmental clearances necessary to proceed to construction. So, first off, to start with, they didn't make the certification that the voters required. And I think just on that basis alone, they violated it. They violated what the bond measure required. And instead, they made a certification that's prognosticating. It's basically saying, well, we will have completed these before we start construction. Well, that can be a promise, but it can't be a certification, because how can they know that they're going to be able to complete them and that they will have completed them. Bear in mind, they're looking at the future, and the authority board that made this certification may not even be the same authority board that decides to start construction. It's now 2 years later, and they still haven't started construction. So who knows how long it's going to be before they go to construction, and who knows who's going to be on that board. How can the board of 2011 certify something that a board in 2013 or later is going to do? I don't think they can. And it's not even a matter of like with the funding, where they can say, well, we think it's reasonably likely. This is basically saying they're certifying they will be complete. And they can't certify that. They don't have a crystal ball. But aside from that, the funding was, the certification was supposed to be with regard to the iOS. Now, the authority says, oh, well, but it didn't say iOS. No, it didn't say iOS. But if you look through the whole idea of the funding plan is for an iOS. The funding plan is for a usable segment. And the funding plan identified the iOS as being a usable segment. So the whole purpose of the funding plan is to create a usable segment. And one has to ask, what was the purpose of this certification? Why was the authority required to certify that it had completed all of the environmental clearances? And I think if you look at what the whole purpose of all these certifications was, it was to ensure that you weren't only going to end up with half a project, that you weren't going to end up with what's called a stranded asset, something that could never really be completed, something that was going to be not functional because it didn't have enough funding, didn't have the proper environmental clearances, something had stuck it, and it was going to stay stuck, and the voters weren't going to get what they paid for. So the purpose of these certifications was to ensure that didn't happen. And the purpose of saying for the environmental clearances is to make sure you don't get halfway through building the iOS and suddenly find you've got a snail darter issue. That all of a sudden, there's a problem here with an endangered species under the Endangered Species Act, and you can't complete this project because you'd be violating the Endangered Species Act to do so. So it's saying, no, get all of that out of the way before you start, so that we know you're not going to end up with that sort of a problem later on. And the authority certification just doesn't do that. It fails to meet the requirements that were implicit in what that certification required. So again, we think that the authority failed here, and for those reasons, the funding plan and everything based on that funding plan is invalid.
Zenon, let me suggest that we take about a 10-minute break, and then I'll give you a chance to respond. That way the court reporter gets a little bit of time.
Yeah, that's fine.